Can you get Mr. Gallegos and his counsel?
We're ready, yes. Thank you. Fernando.
May I get your name and date of birth?
Fernando Gallegos, 05-10-05-2005.
Can you clarify your date of birth?
02-10-05.
Thank you, sir. And counsel, can I get your appearance?
Good evening, Your Honor. Mark Adair, Suzuki Law, on behalf of Mr. Gallegos. We've entered a limited notice of appearance. I think out of abundance of caution that I would request the court appoint a public defender because I'm only going to appear for the initial appearance. Obviously, if we're retained, we'll do a substitution to counsel.
Thank you, counsel. And do I have the state on the line?
Yes, Your Honor. Good evening. Ashley Stetson on behalf of the state.
Thank you, Ms. Stetson. We are here today on a new case. We are here for 1 count of murder, a Class 1 felony, 1 count of conspiracy, Class 1 felony, and 1 count of armed robbery with a deadly weapon, a Class 2 felony. And Mr. Adair, did you want to discuss probable cause, release conditions, or both?
Both, Your Honor.
Okay. And did you get an opportunity to review the Form 4?
Just the Form 4. I was not provided the PSA on the case, but I have seen the Form 4, and I thank you for letting me have the opportunity to review it and discuss it with my client.
Of course. And did you get the state's recommendation?
I have not.
Okay. We will go over all of those things. So, Ms. Stetson, he wants to discuss probable cause along with release conditions. So, can you give me the state's request as it relates to probable cause only at this time?
Yes, Your Honor. Before the state gets started on the probable cause, the state submitted a motion to seal the Form 4, Your Honor. The state is requesting that the Form 4 be sealed for the time being. Your Honor, this is an active investigation. The state is requesting that the Form 4 be sealed to protect the integrity of the case. There are potentially other suspects involved in this case, so and they have not been apprehended, so that is the reason for the state's request. In doing so, that, Your Honor, the state would ask, Your Honor, to advise counsel not to disseminate the Form 4 or counsel and his client not to discuss the contents of the Form 4 outside of their relationship. Thank you, Your Honor. But in regards to probable cause, the state does believe that that there is probable cause. There is an eyewitness that described the suspect. But given the fact that the state is requesting the Form 4 be sealed, the state is very apprehensive to give that much information. But the state does believe, based on the contents of the Form 4, that there is probable cause. Thank you, Your Honor.
Thank you, Ms. Stetson. And I am inclined to grant the state's motion. Counsel, do you have any objection to that?
Well, I even before the statements were concluded, I was thinking, certainly based on my conversation with my client and the charge of conspiracy, and there's not one mention of anybody else, I would thought that there probably was somebody else at large. So, no, I don't have an objection to the court granting that motion at this time.
Thank you, counsel. The court will grant that motion. Let me mark that, and then I will give you an opportunity to respond to her probable cause information.
And I'll avow to the court that I've been practicing for 34 years, and I will certainly respect the state's request.
I do appreciate that, counsel. Okay, and the Form 4 has been sealed. All right, counsel, and your position as it relates to probable cause.
Thank you, Your Honor. We have 3 counts here, and I understand that the level of PC, the threshold of PC at this level is rather low, but you do, as the judicial officer in this case, are limited with what you have in front of you, which is the Form 4. The state is submitting purely on the Form 4 without providing any additional information. So I'll take the easy one, the low-hanging fruit, if you will, the conspiracy charge. As indicated a moment ago, there's absolutely zero information in this particular Form 4 probable cause statement by the booking officer of anybody else involved. As the court is well aware, a conspiracy only requires an agreement between at least two people to commit an illegal act, and one of those persons taking a step in furtherance of that act. The only persons that are mentioned in this particular Form 4 are Fernando Gallegos, my client, the victim, just identified as victim, and victim's girlfriend. I do not see anything in the Form 4 talking about any sort of an agreement, whether it was through this messaging that apparently law enforcement obtained between Mr. Gallegos and the victim's girlfriend. There is an allegation that there was some communication between Mr. Gallegos and the deceased victim. However, as the court is fully aware, the victim cannot be a party to a conspiracy. I think that is certainly the most obvious omission in this probable cause statement, to have booked him in on those charges, or the charge of conspiracy. There's just absolutely nothing in the Form 4 that would indicate that there was any sort of an agreement to either do a lick, do a robbery, commit a murder, anything like that with anybody else. There's no mention of anybody else. So I would respectfully submit that there is absolutely zero information that support any sort of finding of probable cause as pertains to conspiracy. As to the murder, I see that the charge or the statute that's at least listed in the Form 4 is our statute under Arizona law talking about committing or death resulting in committing one of the enumerated felonies there, which is supposedly armed robbery. The problem I'm wanting to point out to the court with respect to the armed robbery comes from not just the written narrative, Your Honor, but also the pre-check boxes that the officers fill out. And I'm specifically referring to page 2 of 5, talks about the arrest of my client, saying defendant was armed when arrested with a small caliber firearm. However, the written narrative talks nothing about any sort of firearm being found on him. Apparently, Mr. Gallegos was arrested by Mesa PD. This case, the homicide, the deceased was located in Tempe, the Tempe marketplace. There's not really, I don't think, a good explanation of how Mesa police became involved, especially when they indicate that they were set up on his residence in Tempe. But regardless of that, the finding of a firearm small caliber is something that I think the court should pay attention to, only in this sense. The narrative talks about a 9mm casing and actual bullet. I don't think that there's any possible way that the state could have forensically determined that the actual bullet is the 9mm, but a casing with its head stamp, I think that could be easily determined. A small firearm, particularly a 22, a 25, a 32, maybe even a 38, not a 9mm. Mr. Gallegos was not found with any firearm on his person when he was arrested, either by Mesa PD or then later transferred into custody of Tempe PD. My client has indicated that the state has done paraffin tests on him, and those can be done rather quickly in terms of results, whether they're even handled or fired a firearm. There's no mention of that in here at all either. So I don't know if this is the proper subsection of our first-degree homicide statute, if it's more like a felony murder type of charge. But again, the state is resting on what's in the Form 4. There's no mention of anybody else. So if the allegation is that the other conspirator, if that's what I can say anyway, based on what I can read between the lines, so to speak. There's nothing putting that gun or a gun in Mr. Gallegos' hands. No testing to confirm that. Obviously we have a deceased person here and we cannot overlook that. I understand that. But our job here tonight is determine whether there's probable cause for this particular individual that stands before the court now. I find it interesting that the victim's girlfriend apparently hears her boyfriend calling out to her. She gets out of the car and then hears the shots. So it doesn't say she saw the shots, but she hears the shots. She's able to provide a perfect description of my client down to the clothing he's wearing, but there's no mention of anybody else, at least it's included in the Form 4. But it's curious to me, and again, all I do are homicide cases and sex defense cases, that there's no mention at all about who shot or if there was another person involved in the case. I know that ties a little bit to the conspiracy argument for lack of PC, but again, the surveillance that is mentioned in here, there's just, apparently nothing captures the actual shooting, or at least it's not referenced in here. I don't know that there is a vast amount of information in this PC statement that the state is resting on, saying that my client committed the armed robbery. It doesn't even talk about him tussling with it. Again, she got out and heard it and must have saw something about pertaining to the robbery itself, but the shooting, I just don't see that there's any information tying that to him. I mean, I would respectfully suggest that I think that there's a vast lack of probable cause with respect to the homicide, at least as the subsection of the statute that the state has alleged in this particular case. The armed robbery itself talks about there was going to be an exchange of apparently money and a ring from the victim to Mr. Gallegos for a Glock handgun. That is not indicative of a robbery. Now, I understand they could have gone there and decided we are going to do a lick and we're going to rob him, but I find it interesting, while they find a box in this car, which we don't know if it was just Mr. Gallegos in or if anybody else was in, they don't talk about finding a Glock. They don't talk about any sort of cash on the victim or on my client. In fact, the Form 4, the numbered sections that they fill out, they indicate that there was no cash found on him at all. Again, I don't know that there is enough here to support that there was a robbery committed by this individual who is standing before the court today. So with respect to those other two charges, both the murder and the armed robbery, it's my, again, respectful suggestion that there's a lack of probable cause. That's my argument on the PC aspect of it.
Thank you, Mr. Adair. So the court is going to find probable cause as it relates to the murder charge and the armed robbery charge. I do believe you have brought up some valid points as it relates to the conspiracy as the Form 4 is with us today. So with that being said, Ms. Stetson, I'm inclined not to find probable cause on the conspiracy theory unless you have additional information you want to provide to the court and to counsel on the record.
No, Your Honor, the only information that the state has in regards to the conspiracy charge is outlined in the Form 4. The state does believe that based on the messages outlined, that there is the suggestion that a conspiracy charge does exist, Your Honor.
Thank you, Ms. Stetson. So I'm going to not find probable cause today for conspiracy. I am finding probable cause for the other two counts. I am going to appoint a public defender in this case. Counsel, as you mentioned, if they hire you, you will file the appropriate paperwork. We are going to have a status conference December 8th at 8:30 and a preliminary hearing December 11th at 8:30. Those are both going to take place at the downtown Superior Courthouse on 175 West Madison Street. Next, we're going to discuss any release conditions. Ms. Stetson, he didn't get a copy of your recommendation. Would you mind putting that on the record for me?
Yes, Your Honor. Let me pull it up real quick. Yes, Your Honor. The state is asking for a bond to be set in the amount of $1.2 million cash. And in regards to conditions, the defendant or suspect shall not possess any firearms, not return to the incident location, no direct or indirect contact with the victim, witnesses, or the next of kin, obviously the family, not to consume any alcohol or ingest any illegal substances, electronic monitoring, house arrest and curfew, and no contact with the co-defendant. In regards to the reason for the state asking for the $1.2 million cash, Your Honor, the state would bring to Your Honor's attention the fact that there are messages that suggest that the suspect did go to the location planning on robbing the victim, Your Honor. Also the link that the suspect went to avoid apprehension in this case, while this did occur on the 1st of December, meaning yesterday, the suspect was not picked up until today, Your Honor. There are, the Form 4 does lay out information in regards to that, Your Honor. The state does acknowledge that the suspect is 20 years old, that he has no criminal history. However, Your Honor, the lengths that the suspect went to, the fact that he was allegedly planning on committing an armed robbery that turned into a murder of a 19-year-old, Your Honor, that also gives the state concern. There's obvious concerns for the community of the safety of the community, Your Honor. The state would also note that the state did review the victim's impact statement. The state did not receive that until after it had completed its recommendation. The state would also mention in regards to the victim impact statement, it does appear that the mother of the victim did write that, Your Honor. She did request that the suspect be held non-bondable or on a $3 million cash bond. Your Honor, this could have been completely avoided had the suspect on December 1st not decide to go commit an armed robbery and ultimately allegedly shoot and kill the 19-year-old victim. So the state is asking for the $1.2 million cash bond, and that's all. Thank you, Your Honor.
Thank you, Ms. Stetson. And Mr. Adair?
There's a lot to unpack, Your Honor, so a minute, please. Bond is obviously set for protection of the community, but also to determine whether the client's going to make future court appearances. As the court is aware, the law in Arizona is that persons should be released on their own recognizance unless there is information, credible information, to believe that additional conditions are required in the case. As the state has pointed out, my client is young. He has zero criminal history, misdemeanor or felony. Therefore, he has zero FTA history. And I find it interesting. Again, I have to keep coming back to this, but the state must rest, or is resting, and has repeated that to this court, on what is in this Form 4 and then obviously the statements. The fact that the state is saying that my client planned to make a robbery is nothing more than a statement from the state prosecutor tonight. If you look at the Form 4 and we talk about any exchange of information, the best reading, the most logical reading you could have of that discussion that's referenced in here is that my client, again, if it comes from his phone, because they say it didn't come from his phone, but the victim's phone, that there was going to be an L, which is supposed to stand for a lick, that this happened, was not a pre-planned event, but something that happened afterwards. It's already in the press that there was an exchange of gunfire in this case. It wasn't that I want to go do a lick and I'm going to shoot this guy to get this property. It's already out in the press, the media, that it was an exchange of gunfire. Again, nothing mentioned in the Form 4, and I understand they want to protect the integrity. But for the purposes of this hearing, this is what this court must be limited to. So the state can't have it both ways, Your Honor. Making the statement that this was how it was going to happen, but not have it supported in here, and then request a bond that is only designed to keep him into custody. And that is not a proper basis. There's numerous cases, a lot of case law on this point, that a bond of that magnitude, and you have to take into consideration, pursuant to our statute, his financial ability to even pay the bond. That is a factor that the court must consider. He is 20 years old. He went through 11th grade in high school at Westwood in Mesa. Then he converted to online. He didn't complete that, was having some difficulty, and now he works full-time at Amazon. He is a full-time employee, but he's an hourly employee. He doesn't make a lot of money. Of course, his family did hire our firm, at least for purposes up to this point for the initial appearance. So he's getting family assistance in that regard. Without any sort of criminal history, and again, with what facts we do know, I understand that there's a deceased person. I don't want to minimize that. It's difficult when you have those kind of situations, but we have to focus on what the statutes, the rules of criminal procedure in the state of Arizona require when it comes to setting release conditions. If the default position is an OR release, and for the state to come in and ask for 1.3 cash only, that's punitive, purely punitive, and again, it's purely designed to keep him into custody. I suspect it's because they want to, again, protect the integrity of their investigation. But again, the state has to deal with what's dealt them. Just like as defense attorney, I have to do the same thing. A bond in this case might be something that, obviously the court has discretion, could be considered, but it has to be something that is reasonable and achieves the purpose of bond, Your Honor, not just to keep this individual in custody, because that's where the state wants him to be right now. Is it going to protect the community? And is it going to assure future court appearances? You put money on the line and say he's got to post some sort of a bond. Of course, he now has skin in the game. I understand that. But this court can use all kinds of alternative methods. He could be released to the third-party custody of his mother, his sister. They could put ankle monitoring on him. They can monitor him that way. They could put him on a curfew. There are so many things this court can do other than just imposing a $1.3 million cash-only bond. There is no indication that this was a planned robbery at all. You know, a month from now, I could be making some sort of a motion or, filing a request for a jury instruction for self-defense. I don't know. This is what I'm limited to. I can read between the lines, but that's not enough, Your Honor. We have to go with what's here. So again, state making its statements now, I understand it, I respect it, but I have to also respect the process. My, again, humble request is, if the court believes that a bond is a further assurance or protection that is needed, that a much more reasonable secured bond would more than accomplish that, again, with the additional conditions. I just heard the state list a half a dozen people that he shouldn't have contact with, co-defendants, but we don't want to talk about a co-defendant, victims. I only know of one victim. That victim's deceased. Again, I think that it's kind of routine. I think that it's just very typical. And I would, again, respectfully suggest that he would make future court appearances, a more reasonable bond, a secure bond. No more than $100,000 would be more than enough to ensure the protection of the community, again, with any additional conditions the court might feel is appropriate.
Thank you, Mr. Adair. So I have reviewed the allegations in this case. I have also reviewed the criminal history or lack thereof in this case. I've reviewed the victim statements. I've heard from your attorney. I've also heard from the state. And with all of that, and I've also reviewed ARS 133967, which does give me the information on what I have to take into consideration when I'm setting a bond. And some of those things include, as your counsel had mentioned, the views of the victim, which I do have a victim statement here, the nature and circumstances of the offense charged, And the list goes on for about 15 different factors. After I have done that, I am going to adopt the state's recommendation. There is going to be a cash bond of $1.2 million. In the event that is posted, you will be released to the supervision of pretrial services and equipped with electronic monitoring. You will have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. You may not possess any weapons or alcohol, and you may not have contact with any next of kin of the alleged victim. All of this will be in your paperwork. This does conclude our hearing. Counsel, feel free to use that room if you would like to continue your conversation with your client, okay?
Thank you, Your Honor.
Thank you, Ms. And Ms. Stetson, are you appearing on the next case? Oh, thank you. And officers, I intend to treat the next one as a knock. Can they hear in that room? Okay. Let's take a quick recess. I've got quite a few warrants piling up and give them a few minutes to speak, and then we will proceed with our last case.